Well, hello everyone. It's Trevor Horwitz speaking. I want to welcome everyone to the InfraGard Atlanta's webinar series. This week, our webinar series is Unwrapping the European Union's General Data Protection Regulation. So we're looking forward to a great webinar, and I want to thank everyone for attending. So to kick things off, just a quick note about InfraGard. InfraGard is a non-profit organization that serves the public. It serves a private-public industry partnership among U.S. businesses. We're involved in protecting and providing resilience for U.S. critical infrastructure. I know some folks who are joining us are part of InfraGard, and I want to thank you for that. If you're not part of InfraGard, we encourage you to apply. There's a process and to go through to apply for membership, and you can reach out to the infragard.org website to do that. A quick disclaimer that none of the opinions in the webinar are that of InfraGard Atlanta, the InfraGard National Members Alliance, or any of the individual organizations. Our opinions are basically our own. So without further ado, just want to also reach out and thank our chapter sponsors. This is the InfraGard Atlanta chapter sponsors. We have BlackBerry, the SNAC, and we appreciate your sponsorship and interest in supporting these activities. The webinar is also sponsored by iTrust. iTrust is a third-party cyber risk management platform, and we'd like to thank iTrust also for their support in allowing us to provide these to our large audience at no charge. So let's kick things off and introduce our panelists. Our first panelist is my colleague, Ward Piles. Ward and I have known each other for many years. Ward, do you want to say a few words?
Yeah, thank you so much, Trevor, and appreciate everybody being here and to be a part of this. So I work at IHG, Intercontinental Hotels Group. We are a global hotels organization that is exposed to GDPR. We are out of the UK, headquartered, so definitely the considerations for GDPR for us and our guests and employees is definitely pretty significant. So really glad to be here.
Thanks, Ward, and thanks for being part of the panel. My second panelist is Bruno Herring. Bruno is a thought leader in the space. Works for Pricewaterhouse. Bruno, do you want to introduce yourself?
Yeah, good afternoon, everyone. I'm a director in our cybersecurity and privacy practice here based out of Atlanta, serving mostly the Southeast region. And you guys can imagine GDPR is something that is in high demand and that we're helping clients in every industry from every regard, assessment, implementation. So a lot of good perspectives that hopefully I can share, and happy to address questions that may come up as part of the discussion. Humble to be here.
Thank you, Bruno. Thanks, Bruno, and thanks again for being part of the panel. And finally, our last panelist, David Katz. David, introduce yourself, please.
Hey, good afternoon, everyone. I'm a partner at Nelson Mullins, Riley Scrubber. I lead the Privacy and Data Security Practice Group, and like the other panelists, we're getting a lot of questions on the GDPR, and thrilled to have an opportunity to talk to everyone today.
Thank you, David. And lastly, myself, again, Trevor Horwitz, a former president of the InfraGard Atlanta chapter. And I don't know much about GDPR, but I did stay at a Holiday Inn Express last night. So I also involved in GDPR at, you're welcome, Ward. I hope I get some credit for that.
Sure.
So I'm also involved in our cybersecurity practice at Trust and in 12 months. Just a couple of housekeeping things as far as the presentation that will be available afterwards. There'll be a link sent to all attendees. So if you want to review the presentation, happy to provide it to you. If you have questions during the webinar, please send them to us. We love having interactive webinars, and we'll have at least a few minutes at the end of the presentation to actually answer them. Our agenda for today is going to cover a number of different topics. It's kind of packed. So we're going to start off talking about governance and accountability, and then from there we're going to talk about privacy by design. So we've got about 12 topics to talk about, and then again, as I said, we'll look for Q&A right at the end, and we're going to have some polling questions during the presentation as well. So look out for that. So I just want to make sure everyone had this donut picture, and the reason that I put the donut picture in is because even if you didn't like the presentation today, at least you can go back and say, well, not much of a presentation, but they did have nice-looking donuts. Okay, so without further ado, I'm going to ask David to kick us off. And David, if you could just give us your GDPR in 90 seconds, an overview of GDPR for our audience. Go ahead.
Sure. GDPR in 90 seconds is probably the greatest challenge of my career, but I'm going to go ahead and do it. So one of the things that we hear from clients very often is that it's very challenging to get their arms around sort of the scope of this regulation. And the first thing I can tell you when you download this regulation, where you should focus your attention is the preamble. So the preamble has 173 short summaries and guidance for each component of this regulation. So it's invaluable that you familiarize yourself with that preamble and learn to navigate through the chapters and articles and the various cross-references within the text of the regulation. So part of what I'm going to do in my 90 seconds is just tell you some of the highlights from that preamble as a way to kind of give you the big ticket items that I think are important to focus. So just by way of history, this is a revision of the Directive 9546 of the European Commission, which was passed in 1995. So the evolution to GDPR has been a 20-year process in the making. It was passed in April of 2016, which means it was effective then, and it's only the enforcement that begins May 25th, 2018. It applies to personal data processed in the EU, and as I'm sure many of you know, personal data has a much broader definition than what we typically see being protected under U.S. law. And personal data is really any information relating to an individual or identifiable natural person that can be identified directly. And there are other definitions that are really critical to understand as you're beginning to think about your process around who's a controller and who's a processor. And also the member states that are in the European Union have their own applicable laws that incorporate and modify the GDPR, a pretty important thing to understand. And the protections apply to natural persons, whatever nationality or place of residence, in relation to their processing. So that's in the preamble also. The processing of personal data by controllers or processors located in the EU is also required to be carried out under the GDPR, regardless of where that processing takes place. The processing doesn't apply to anonymous information. Natural persons can be associated with online identifiers with their devices, so like an IP address. Consent has to be clear and affirmative, freely given, specific and informed. Data subjects should be provided the ability to facilitate access and correction of their data. And there's a breach notification requirement of 72 hours. So those are some of the highlights. And before my 90-second runs out, the important thing to also remember is that Chapter 8 talks about the data subjects have the right to lodge complaints with supervisory authorities. So it's not just the fines, it's also the ability of data subjects to bring suit in the member states. Article 83 outlines the imposition of fines, and there are 11 key factors to determine whether fines are imposed in two fining regimes. One, 10 million and 2% under certain provisions, and 20 million or 4% of global revenue. And there are 5 categories that we're going to be talking about a little bit later that apply to these fines. So I may have gone over the 90 seconds, but that's the high level in a nutshell of some of the things we're going to be talking about today.
Thank you, David. So I also want to highlight just 2 things on there. Well, one thing actually which is the second to last bullet point, which is there's no formal compliance attestation. So I want to contrast this with something like PCR, where there's an annual assessment process, and contrast that with something like HIPAA, which operates by course of law. So GDPR falls into that second bucket. There's no GDPR assessment that you can actually do, or anything that you actually have to send to the government. We'll talk a little bit about compliance assessments and how that work, and there are sort of certificates you can get which validate GDPR compliance, but there's no formal attestation that's actually required. So moving on from there, why don't I turn this over to Bruno to talk about governance and accountability. Bruno?
Yeah, thank you. Sorry, I was on mute there. So governance and accountability, this is the foundation of it all. Companies often struggle in terms of how to set up a privacy program. One of the biggest mistakes we have seen clients make is treating GDPR as a silo and not taking the opportunity to implement a privacy program holistically, enterprise-wide, or on a global basis. The reason that's happening, why we're seeing companies not treat GDPR as a silo, is because there are many requirements that are coming from a privacy perspective from different countries. China is one of them. We expect India to follow suit here really quickly. And we're already seeing the split from the UK and the EU, and they're going to come up with their own version of GDPR. So that's the first and foremost, one of the most important aspects of GDPR is viewing this as an opportunity to set up a privacy program that, if you will, takes into account GDPR. But the fact is that GDPR is the most solid framework out there as it is to GDPR, meaning that if you comply with GDPR, you're more than likely to have 90% or more requirements already met for any other privacy obligation you may have. And of course, it's a great leading practice for anything that you do in the U.S. So starting up the privacy program and the governance behind that becomes key in order to achieve that. So having the right sponsorship, obviously, in the organization, having the commitment from upper leadership, C-level suite, et cetera, being able to have the right communication plan in place, and being able to document a solid strategy that both the business, upper leadership agree with, and they all see they all feel about the risk appetite and thresholds in the same fashion throughout the organization. That really is a very important thing as you come into having the right framework in place as well to address the privacy risks. So as you may or may not know, you need to be, everything that you're doing from a GDPR perspective, including governance, need to be auditable. So how do you go about making sure that you're auditable from a governance perspective? When it comes to the risk appetite that I was talking about and dealing with compliance, having an audit framework or a privacy framework that you can adopt it becomes key as well. This is important as you think about the sponsorship as well and the tone at the top, because these allows the set of metrics to be in place so somebody can evaluate the privacy program in order to decline coming from a regulatory perspective. The DPO, the protection officer, it's a requirement as part of this. It's a protected role in the organization. It's a protected position, reporting directly to the supervisory authority and the CEO level. So it kind of behaves like an internal audit, CAE type role. There are some thresholds. It's not necessarily applicable to everybody. There's some things that you need to consider in terms of volumes of a transaction, types of data, overall risk, and you need to document your thought process to make sure that if you're audited or if asked about your rationale about appointing a DPO versus not, that you are clearly well documented there in terms of how you do that. And of course, a lot of change in the organization will come out of this, especially how you do business, when you need to embed privacy in everything that you are basically managing, rolling out, or deploying. So the whole training aspect of and change management that comes with it in the organization becomes key. So obviously the right level of testing is going to be required and things of that nature. And lastly, the insurance comes into play because different thing, the risk profile of everything you're managing becomes a little different now. And you need to account for that in the event that you have any complaints by citizens, EU citizens, subpoenas or audits and penalties and things of that nature. So you need to be adequately considering those things as well as you go through the privacy strategy, which again is a key element of overall privacy governance.
Great, thanks, Bruno. Moving on from there, we're going to dive into privacy by design. Ward?
Yeah, so one of the things that Bruno is actually highlighting there, which is a key piece as you look at the governance, is considering privacy as part of the entire business structure. And that's really where GDPR is looking at and really suggesting and trying to drive organizations towards, and that is privacy by design. And privacy by design is not something new or unique or has never existed before. It's something that many of you may have already been familiar with, and it's existed for a number of years in the security and legal communities and businesses. But now you have a entity that is actually calling it out specifically within GDPR and setting an expectation around it. So with privacy by design and embedding it within the lifecycle development of your systems and your processes and your software development lifecycle, for instance. But the idea of privacy by design is considering where and upfront what personal data you want to use, for what purpose, and how will you do this legitimately within your organization. So taking all those things into consideration whenever you're designing, and by doing that, you are performing a privacy impact assessment, or you may look at doing a privacy impact assessment for your entire enterprise. And as part of that, you look at evaluating and understanding the privacy considerations on projects and systems, and then you may go even to the data privacy impact assessment. So data privacy impact assessment identifies the most effective and ways and utilizes ways to provide assurance and security of data throughout your environment and within your infrastructures that you've identified as part of that privacy impact assessment, and where data and personal data aligned with GDPR or otherwise that is identifiable to an individual may exist within your environment. So performing these required tests and as part of the structure of business is now required under GDPR and set as an expectation.
Great, thank you. I think we're going to talk a little bit more about the privacy impact assessment and how it relates back to cybersecurity itself, which is kind of one of the slides coming up. So let's move on to the next topic, which I'm going to ask David to address. David, the next topic is lawfulness of processing and conditions for consent. Now, that certainly sounds like a phrase that was made up by a lawyer.
Right. Yeah, so just, by way of background, I mean, this is Chapter 2, and this Chapter 2 consists of Articles 5 through 9. And this is another section of the GDPR, which, if there's a violation, would put you in the 20 million, 4% of global revenue fine criteria. So the principles are made up of the principles related to the processing of data, lawfulness of processing, conditions for consent, and then conditions applicable to children's consent, and then the category of Article 9 of processing of special categories of data. So I'll run through this quickly, but just to go to the slide quickly, yes, the GDPR is going to require every institution, every organization to operationally be able to account for every single piece of information that's being collected from European citizens. And so, understanding what you're doing, how that data is moving through your organization, and who you're sharing it with is a critical first step. And ensuring that you're operationally able to account for that data and that you can account for withdrawal of consent for that data is also important. So I'll run through the principles quickly so we can understand kind of how they're comprised. Article 5 outlines the principles, having to process lawfully, fairly, transparently, and that it's collected for a legitimate and specific purpose, and that it's not being processed incompatible with that purpose, that it's minimized, it's limited to what's necessary, that it's accurate, and that you take steps to ensure accuracy and the ability to correct or erase, that it's kept secured, and that it's kept in a form that permits its identification of the data subjects for only as long as necessary. And one of the sort of player tips that I think it's important for people to know is the Article 29 Working Party, the collection of the member nations and the Commission representatives. They are constantly putting out additional information on how to interpret the GDPR. It's very broad principles, and the questions come is, how does this apply? What should I be doing? Where's the guidance coming from? So if you want some more details about how this is being viewed, the Article 29 Working Party is where these white papers are being developed to explain. So, and they've just published one on transparency. So under Article 5. Article 6 is the lawfulness of processing. If the below 6 don't apply, then there is no lawful processing taking place. So those 6 are that the data subject has given consent for one or more specific purpose, the processing is necessary to perform a contract, the processing is necessary to compel a legal obligation, comply with a legal obligation, necessary to protect a vital interest, perform a task carried out in the public interest, for the purposes of the legitimate interest or controller, balanced against the interest of the overriding the fundamental rights and freedoms of the data subject. Now that last one's a little broad and may require some more analysis and is kind of a catch-all, but those are the only reasons really that data can be processed from a lawful perspective. And the interesting thing is that member states can introduce more specific provisions under Article 6. So you really, not only do you need to know the GDPR, but you need to know within the member state if there have been additional requirements added. What are the conditions for consent? You have to be able to demonstrate that it's been given. And that can be done in writing or electronically. And there's a right to withdraw at any time. And prior to giving consent, the data subject should be informed that it's as easy to withdraw as it is to give consent. And so when assessing whether consent's freely given, they're going to take into account whether there's an inducement by contract, whether it was conditional on the consent of processing. And so it's an important thing to remember of actually how consent's obtained. I'm going to skip on the child consent just to get to Article 9. Special categories of data are racial, ethnic, political opinions, philosophical beliefs, trade union membership, and those are prohibited from being processed without being done under 9 specific exceptions. And some of those include explicit consent, exceptions for employment and Social Security, to protect a vital interest or protect public health. So, that section involving the principles 5 through 9 is a really important one to understand, and again, falls into the category of the big fine. So, really critical to make sure you're in compliance with those.
Great, thank you. Moving on from there, back to Bruno. Bruno, give us a quick overview about notices and vetting.
Yeah, I'll be brief on this one. I think companies need to revisit what they're putting forth in terms of notices. A lot of things with GDPR have significant changes on timing and the extent of the notices, the content in the notices that need to be transparent to employees and customers, including timing, the reason and types of data that are being captured, which I can go into a little detail here in a second, but you got to understand that these are things that, as GDPR is rolled out on the organization, you need to think about how you need to proactively do that for employees or customers. And this is not for new employee or customers going forward. You need to go backwards and really revisit this for the entire base that you have from an EU citizen information. To make sure that everybody is adequately being notified about how you're treating data and things like that. And, the key requirements from a notice perspective is going to be mostly around the purpose and the legal basis of what you're processing and why. You need to have legitimate interest in terms of why you're using that data. GDPR is big on minimizing data that you don't need or getting rid of it and things like that. So you always need to have a documented purpose and legal right, of course, to be using that data, and you need to obviously be transparent on that to the customer and the employee. This also includes things such as data retention periods that may change, just given the new lens from a GDPR perspective. The presence or logic of automated decision making. So if you have systems that are processing on an automated basis, that is the information about notices and privacy rights, elections, and things of that nature, EU citizens may opt out of that specifically, and you need to have the ability to be able to dissect the people that do want to have their data being processed automatically by a system versus a human being, if you will. So your notices need to have all that information so the EU citizen know exactly how your data, their data is being handled, how it's being used and for what purposes, and including if it's a machine or a human being behind it of it all to deal with the data. And again, timing of notice becomes important as well. So when do you notify directly the data subject? If you do that, the collection of the data or after you're collecting it, Obviously, GDPR is pretty strong in that regard, and there are always going to be exceptions to the rule. The exceptions to the rule could be things along the lines of any laws or regulations from a specific country or professional or statutory secrecy type professional obligations that may be in place. The same applies to right to be forgotten, which I know was one of the questions. So clearly a critical component as you're putting together the program.
Great, thank you. So moving on from there, Ward, tell us a little bit about how this impacts children.
Yeah, so David actually touched on it a little bit earlier. You may have all identified it or picked up on it. One of the specific things within GDPR is the identification of children and the relation of children as it relates uniquely to protections of their information and the expectations of compliance and notice within those for children as well. So one of the big ideas is for children, it's because they may be less aware of the risks and consequences and the safeguards that are within the systems. So the idea within the GDPR is to protect them more. GDPR specifies the age of a child as ending at age 16, but did leave member states the ability to adjust between the ages of 13 to 16. But one of the considerations and really highlights whenever it comes to children is the expectation on the data controller to make sure that their privacy notices are specifically readable in a child of age format and commonly for those expectations. So whenever you're creating your agreements or alignments for the protection of children, as it is with the GDPR, you must be providing a readable format and content that is absorbable to someone of that age that you are marketing and directing the content towards.
Well, that seems like it's going to be very challenging, particularly when you consider all the language barriers there are, and then on top of that, different age restrictions in different countries. Seems like that's going to be quite a challenge for organizations that deal with data concerning children.
Yeah, I agree. We're definitely monitoring and waiting to see kind of where the rules will land to some extent, and the expectations as more guidance and otherwise comes out around and specific to the ages of children and the expectations therein.
Great. Okay, moving on from there, back to David. David, talk to us about data subject rights and procedures.
Sure. So again, Chapter 3, this covers Article 12 through 23. It provides all the information around both these topics. And again, you're in the 20 million, 4% territory for not complying with these requirements. So Article 12 basically lays out the requirement that you have to communicate in a transparent, concise way, intelligible, in an easy format. Your customers have to be able to understand what you're doing with the data, and they're very specific requirements in terms of what you're obligated to communicate to them. And again, the guidelines on transparency under the regulation, which is the Article 29 Working Party document, provide a lot of detail around these particular articles and very, very helpful in terms of what you need to do and how to create layered privacy policies. So what is it that you need to be communicating? Article 13 outlines the information that has to be provided to the data subject. So it's identity and contact details for the controller representatives, the contact details for the data protection officer, what is the purpose of processing and legal basis, where is the processing and what's the legitimate interest being pursued by the controller, who's getting the data, who are the recipients and categories of the recipients for that data, if data is going to be transferred to a third party, and you have to communicate this at the time the data is obtained in order for you to be considered to be ensuring fair and transparent communication. You also have to tell about the period of the storage, about the right of access and erasure and rectification, where the processing is based and how to withdraw consent, the right to complain to a supervisory authority, whether provisioning of data is statutory or contractually required under this arrangement, and the existence of automated decision-making, including profiling that's occurring. So even going through that exercise, just in terms of 12 and 13, is going to allow your organization to really begin to sort of answer some of these tough questions. And then 15 through 19 really get to the questions of access, rectification, or right to be forgotten. And I did see a question about right to be forgotten, and there is an exception in that section in Article 17, where the right to be forgotten won't apply to the extent that processing is necessary for compliance with a legal obligation. And so, where there are conflicting statutes and obligations on the part of the controller, you'd have to really do the analysis to determine if that exception could possibly apply. So, there's the right of data portability. You have to have your data structured in a machine-readable format in cases where processing is based upon consent or a contract that the processing is being carried out by automated means in order to be able to give people that data. And to the slide's point, all of this requires a very detailed operational knowledge to make sure that these things can be put into place. And then Article 21, the final article in this section, the right to object can be made at any time, and the controller can no longer process that data. Very, very important section in terms of what's permissible.
Great, thank you. Very interesting. Moving on from there, I'm going to ask Bruno to talk to us about a record of processing. Bruno, how does this interact and how does this relate back to our audience in terms of what they need to do? Bruno?
Sorry, mute again. My bad. Going back to the comment on auditability, these are things that you need to have very well documented in terms of how is it that you're using your data, how is it that you're processing it, the types of information that you are handling, using, processing, storing, such as, beyond your social security number, IP address, it could even be, religious preferences and things like that. So what are the specific data elements that trigger the compliance effort or the compliance requirement? And from there, determining how you're going to process it, how you're going to secure it, protect it, in transit, at rest, and use. And one thing that is becoming significantly helpful for organizations, and alludes to the final bullet there, is a data flow map. So we're going back to basics. We're seeing a lot of organizations going and documenting data flows, putting all the right inputs, how all the means that data can get in, where does it go, does it get aggregated, does it go for other databases for other purposes, how's it being processed, again, a human being versus machine, and then at each layer or each point, how is it being secured during, again, transmission, use, or when at rest. And, of course, any outputs that come out of that, where is it that data could end up as well? Because then that drives the conversation about the data inventory as well and making sure that you're accounting for everything. But these are all things that need to be very well documented in the event of a supervisory authority coming into requesting this information upon request, or if it's a complaint from an EU citizen that will it will be necessary to have information about these things to get to the right answer. So, like everything else, of course, there's technical organizational measures that will need to be taken to make this work. But again, you need to be very well documented in terms of how you're handling data, including how you transfer to other countries and how do you exchange information with other third parties.
Great, thank you. So moving on to there, while we're running this poll, I'm going to ask Ward to talk to us about contracting and procurement.
Yeah, so whenever we're talking about contracting, it's definitely something that is attentive, and it looks like, based on some of the responses here under legal requirements, it's of high concern to many of you, and rightfully so. One of the big pieces with contracting is now the new expectations on companies to make sure you have the right disclosures and expectations set with your different data processors. And with third parties now, the expectation within GDPR is very high and not just independent to you, whereas, in a PCI world, you're liable and your QSA may be assessing you. Now under GDPR world, it may be something that leaks from a third-party data processor on your behalf, and therefore you are held liable and accountable because it is your customer information that they're managing for you. And GDPR touches on those definitions of data controller and data processor, which you guys can all take a look at. But because of that definition, you are now exposed and also you are now expected to perform and understand what your vendors are doing and how they're operating and managing the data that is exposed and required under GDPR. So implementing a third-party risk management program and also addressing the contractual and obligations and making sure, going back to that privacy by design, whenever you're engaging in those entities and sourcing the work or bringing in those companies for contracts, you need to make sure you're looking at how you consider privacy as part of the life cycle of the procurement consideration for those entities, making sure that the right language is there, and then also that you're performing a assessment that understands the security framework and the data management of your partners and your third parties that are hosting, managing, and interfacing with the data in consideration for GDPR.
That's great. Thank you. So moving on from there, back to Bruno. Bruno, talk to us about data breach procedures. We know data breaches are becoming increasingly common in the world of cybersecurity, and what are people required to do if there is a data breach?
Clearly, incidents are on the rise. Yeah, I'm here. And of course, as it relates to GDPR, they have made or developed strict requirements about how do you handle incident management, incident response. With service providers, third parties, and the like. This really all depends whether you're in the data processor side or the data controller side, first and foremost. So, for example, the obligation is if you are a data processor, you need to notify the data controller without undue delay that you have become aware of an incident, and there are usually no exceptions to that rule. And of course, this is where third-party contracts become a key. Like we mentioned earlier, we need to be able to have those right SLAs and contractual obligations between the parties, so that doesn't become an issue. When it comes to a data controller notifying a supervisory authority, so here's where we see the famous 72 hours from a GDPR perspective. So they are pretty consistent there in terms of saying, look, you let us know as soon as you know, but no later than 72 hours. And if you have a delay or it's beyond 72 hours, then of course you need to be able to have the reasons very well documented and the thought process and evidence to support any kind of request or any type of request from a supervisory authority. There are, of course, some exceptions to the rules, so you can have the risk to the rights and freedom of natural persons and things like that, but for the most part, you are required to notify on or before 72 hours. And if you're a data controller and you, in terms of notifying data subjects, of course, it's as soon as you can, as soon as you know about it. But of course, when it comes to data subjects, you first need to focus on implementing the measures to contain the data breach, which may justify more time for data subjects. They want to obviously you want to be able to protect your brand and notify the customers that things are under control, that you are looking at the privacy as the utmost concern and things of that nature. So clearly it's something that you need to notify as soon as you can, but you need to be tactical in terms of the legal and reputational implications of when you notify data subjects, so that's going to become pretty important. If things are encrypted, and meaning that they're not usable if breached, then the notification requirement is is more flexible. So if at the time of the incident there was adequate protection in there, then informing individuals it may not be necessary because the data is not usable in that regard. So always a lot of legal counsel behind that to determine what's adequate versus not adequate from a safeguard perspective of the data and the level of confidence that you have, and again, having documented that in the thought process so you're able to demonstrate that as evidence.
Yeah, that's great. That's a good segue into the next section, which I'm going to tackle, which is on data security. So data security is called out within the GDPR standard. It talks about security of processing standards. That's Article 32. And then it actually goes on to give some examples The standard basically doesn't specify what the requirements are. It talks about them in much broader terms. It talks about having appropriate technical and organizational measures, but it also looks at that from a perspective of risk. And a couple of things I found interesting when you read through the language of GDPR. It actually talks about having controls that are appropriate based on the state of the art and the cost of implementation, and considering the nature, scope, context, and the purpose of the processing. So all of those things bundled together along with the risk assessment will determine how the information needs to be protected. So I found that very interesting because there's obviously a kind of a scale of when you're looking at data. So I think the important thing when it comes to data security is that you actually do a risk assessment, and that's kind of part of the process. Do the risk assessment up front. As far as specifics in the standard itself, it also calls for a concept of pseudo-anonymization or encryption. So there's a concept, pseudo-anonymization is where you take data and you essentially provide other elements to it so that the underlying individual that the data is associated with cannot be readily identified. And there's technical techniques, there's various ways to do that. But it's interesting that they brought that into it. You can use that and encryption to protect data. And then there's a standard confidentiality, integrity, availability, and of course resilience that are kind of built into any data security posture. And then one of the important things, which is not purely a data security issue, but more from a continuity perspective, is that you have to have the ability to readily restore information in the event of an incident. So backups are obviously going to be critical to that, which again, not necessarily part of a formal cybersecurity practice. Things like PCR, for example, don't care if your data gets deleted. That's viewed as a positive. But in this context, that is important. One other thing just to add before we move into the next slide, and that's there is a voluntary certification process in place. And you can do that through a number of different mechanisms, primarily through ISO. So ISO 27001 is a standard which a lot of European companies have adopted. And that standard will actually, if you can actually check off a lot of those boxes and ensure that you're compliant with GDPR. Like I said, it's a voluntary certification process, but we think there's going to be more companies adopting that because it's specifically called out within the GDPR standard. All right, so moving on from there, back to David. David, talk to us about data exports.
Sure, thanks, Trevor. So again, Chapter 5, another section that is $20 million, up to $20 million and 4% of global revenue, and this covers data export, covers Articles 44 through 49. So this is really a discussion of how you can lawfully move data from the European Union and the member states to a jurisdiction that has not been determined to maintain an adequate level of protection. Who makes that determination? It's the Commission, and Article 45 describes how that decision is made. Article 46 outlines the transfers that are permissible subject to the appropriate safeguards. And there are three carryovers essentially from the earlier directive: the binding corporate rules, the standard data protection clauses, and the certification mechanisms. What's new is the approved code of conduct that's permissible under Article 40 that requires a binding commitment of a controller and a processor. And Article 40 does a good job of laying out what's required. The approved certification mechanism obviously is no longer the safeguards rule. It's now the privacy shield. And before I get into that briefly, I want to just say Article 49 provides for some specific situations that are exempted or accepted from this requirement around data export. But I would just caution, one of the examples is necessary for performance of a contract where the data subject has explicitly consented. This regulation and trying to rely on some of the derogations without a really good analysis and some really good defensibility, I think is a risk at this point since the enforcement hasn't been done. So it's easy to sort of look at this and say, oh, well, these are some exceptions that we fall into, but without really taking the time to go through those and analyze this very closely, I think there's a little bit of risk associated with that. So what is the privacy shield? So for the U.S., there are some requirements, and there's a framework that's been constructed under that certification alternative that's called Privacy Shield. And essentially it requires participants to draft a privacy policy that declare a declaration of the organization's commitment to comply with the Shield. What does that mean? What are the elements of that? It requires you to provide free and accessible dispute resolution for folks that have an issue with how you're handling data. It requires cooperation with the Department of Commerce. It also, by providing that public privacy policy, puts you within the jurisdiction of the Federal Trade Commission, because these are promises that you're making to consumers, and to the extent you're not complying with those, the FTC has an enforcement authority. So again, it incorporates components of the GDPR like data integrity, purpose limitation, accountability for data transfer, transparency, ensuring that there's the ability to rectify and correct data. So again, there are very specific ways that data is moved from the European Union, and the regulation outlines all of those in a lot of detail.
Great, thank you. All right, so moving into the back end of our presentation, just some recommendations here from the panel. So for folks that are starting off and going through this exercise, first thing we're going to recommend is you begin with a GDPR compliance gap assessment. So look at the requirements, go through each of the requirements, and identify where you fit in and where you don't. And obviously, anything that falls out of band requires a remediation. The technical changes are going to be the most challenging and potentially the most costly and time-consuming. So things like implementing customer consent agreements, data access rights, encryption from a technical perspective, those are probably going to absorb a lot more time than some of the procedural administrative changes. So focus on the technical changes. Again, need budget for that, and need to put some effort into getting all of those in place on time. The procedural changes are going to be mostly policies and procedures, and doing things like data protection impact assessments. Those are going to be recurring things, not necessarily have to be done in band, can be done out of band, but you don't have a strict deadline to do that. You should do a data protection impact assessment upfront. You maybe even want to combine that with the initial gap assessment and do that upfront, and then it just becomes an annual process. So going back to the last point, there is no formal requirement, and I think this question came up from some of the audience, there is no formal requirement to you to provide any evidence of GDPR compliance to any regulatory authority on a regular basis. So there's no reporting structure in place. So this operates, again, similar to HIPAA. You're required to do this by law. There's no agency coming after you. Where you will get into trouble is if they do have an incident and there is data breached, and then you're found to be non-compliant, then you need to be able to demonstrate that. So doing an annual compliance assessment and making sure you're not only are doing all the requirements, but keeping up with the changes. David mentioned earlier that there are a lot of changes taking place within the GDPR thanks to the working parties, and so keep up to date with your assessments. So moving on to the tail end, and we're going to take some questions now. Again, just want to thank our sponsors. These are the InfraGard Atlanta chapter sponsors that make these webinars possible. And then to iTrust, who is our webinar sponsor, I want to thank them for, again, providing us the means to communicate with all of you. So let's get into some of the Q&A now. And I know we had a ton of questions come in, and really appreciate everyone making this kind of interactive. Let me start off the first question, which came in here. Under GDPR, what is considered a data breach? Could something as sending an email or a fax to the wrong person be considered a data breach? I'm going to throw that out to David from a legal perspective.
Yeah, thanks, Trevor. Yeah, so in any compromise of personal data as it's defined under the regulation could end up creating the notification requirement back to those individuals. And again, depending on the facts and the analysis that's done, the reporting requirement is very quick. So the key thing for any organization is to be able to, as part of an incident response plan, to have sort of mapped through all of the potential scenarios and the reaction, and make sure that you have a good, solid plan in place to be able to respond accordingly and quickly, obviously.
Okay, and throw this question out. Anyone can answer. Our business has fewer than 250 employees. Are we exempt from GDPR? So is there some sort of size limit or a revenue limit in terms of compliance? Maybe that's kind of a repetition.
I don't think there's a defined limit. I think all it takes is one EU citizen to file a complaint is the unfortunate answer, at least in my mind. The fact is that the whole point behind this is to give the EU citizens a lot more rights and power in terms of what companies, organizations, regardless of size, stature, global presence, etc., to give the right to citizens to be able to protect their information. So if it's a EU citizen, resides in the EU, or has transactions in the EU, things of that nature, it most likely will apply. But of course, the legal counsel aspect of that is key to making decisions like that. So perhaps determining what the data is that you're capturing and for what purposes becomes more of a consideration, if you will, versus whether GDPR applies to me based on size or not.
Great. A question coming in from the audience. Do the same laws apply to customers as well as employees?
This is David Katz. So the GDPR, when you read through some of the specific provisions, there are in many cases within the context of the GDPR, exceptions for obligations that employers have around employment data, obligations they have from a regulatory perspective or a contractual perspective. So it really depends on, the specific scenario that's in question in terms of how that data is being handled. And yes, the GDPR in many places distinguishes between customer data and data that you as an employer need to deal with on behalf of your employees.
Okay, thank you, David. So next question came in, and it's probably a legal question again. Do I always need consent? Are there any other basis for providing consent or allowing people to lawfully process data? David?
Oh yeah. So the answer is there are additional legal bases for processing that are in addition to consent, and some of those we talked about, in my part of the presentation, where they focus on that it's for the performance of a contract, it's for the vital interest of a data subject, so that it's necessary to comply with a legal obligation. It's a task carrying out the public interest. So again, with this regulation, all of the questions sort of need that kind of analysis, and until someone within the organization has gone through the reg and has started to think about, well, how does this apply to us, and really sort of read and really thought through, done the analysis, the reg seems much broader and more confusing until it's put in the context of how the business is actually operating and what's happening in terms of data flows and transfers and those kinds of issues.
Okay, excellent. Okay, folks, we're pretty much out of time now. It's kind of the end of the presentation. We have a ton of questions. What I'm going to do is I'm going to take all these questions and we're going to see if we can answer them. If you reach out to the InfraGuard Atlanta or through our website, we'll provide some mechanism to be able to respond to some of these things. So really appreciate our panelists, Ward, Bruno, David. Thank you so much. You guys are awesome. And we thank you for your time, and we look forward to seeing you on another webinar soon. Take care, everyone.
Thank you, Trevor. Really appreciate it. Thanks, everyone.